Hi, everyone. I'm Diane Macedo. We're coming on the air with breaking news. The Supreme Court has just rejected a challenge to the Affordable Care Act for the third time. The court was asked to decide if the law's individual mandate was unconstitutional now that Congress made the penalty zero, and if so, whether the rest of the law can stand without it. But the justices here have decided that the plaintiffs in this case had no standing to bring the case to begin with. The decision maintains health insurance for millions of Americans, effectively leaving in place the status quo. Let's go right to senior Washington reporter Devin Dwyer. Devin, what does this mean practically for health care and health insurance in this country?
Yeah, Diane, this means the status quo is in place for the health care system in this country and for Obamacare, of course, which was signed into law in 2010. It has been challenged 3 times existentially. This was one of those challenges. And the Supreme Court today punted without even getting to the merits of the question. In fact, Justice Stephen Breyer, one of the liberals, the oldest member of the court, seems to have brokered a compromise here, taking a very narrow approach, saying the plaintiffs in this case failed to show a concrete and particularized injury. The court has argued, of course, that they broker compromises over controversies. They don't decide things that aren't actual issues. Here, as you mentioned, the whole issue of this was the individual mandate, the command that Americans buy health insurance. Well, in 2017, Congress zeroed out the penalty for going without health insurance. And so when these plaintiffs came forward and said, look, we've been injured by this command that we buy health insurance. We bought health insurance because of it. We didn't want it. The court today said, no, you actually weren't injured because there's no penalty attached to it, and therefore there's no controversy. And so we're staying out of it. It was a 7-2 decision, leaving in place Obamacare and that mandate.
And I want to bring in senior national correspondent Terry Moran for more on the political impact here, because, Terry, this was the third challenge now to Obamacare before the Supreme Court. And I wonder what this does for that trend, but also the general trend of trying to use the courts more and more to essentially legislate.
That's a great question, Diane. So for the Republicans, look, this has been one of the major projects of the Republican Party for the better part of a decade. They've tried 3 times. They hate this law. They said it was an act of tyranny. It's become quite popular among the American people, but what they didn't like was the individual mandate in the law requiring Americans over the age of 18 to buy health insurance. And at one point, they actually took what was the penalty. There was a fine, a tax is the way the Supreme Court looked at it. If you didn't buy health insurance, you had to pay money to the government. The Republicans reduced that number to 0. And that's how we got today's opinion. If you don't have to pay anything, if the government can't enforce its command, then you aren't injured. And that's at the bottom of this, because in our country, in our Constitution, courts only rule on actual cases or controversies. They don't just give opinions about laws willy-nilly. And if you don't like a law, you can't just bring a case. You have to demonstrate that you've suffered some real injury that's traceable to the law itself. And what the court here is doing, as you suggest more broadly, is saying, back off with these kind of fake cases, where really the people who are bringing them are political activists, not ordinary citizens who've been injured by the law, but people who are trying to make a point politically using the courts. That's not what we're for, the Supreme Court says. Even Clarence Thomas signs on to this opinion, saying the problem is they have not identified any unlawful action by the government that has injured them. If the government's not going to punish you and you can just not buy health insurance, you don't have a case in court. And that's an important principle that the Supreme Court laid down today.
And I want to go to constitutional attorney and ABC News contributor Kate Shaw for a little bit more on that. Kate, when you look at the language of the way this decision came down, what do you think it does not only for future cases against the Affordable Care Act, but future cases before the Supreme Court in general?
Well, I think the case says something pretty important about the Supreme Court, which is whatever the party of the appointing president, certain legal principles sort of transcend ideology and partisanship. And the idea that Terry was just describing, which is that courts don't get to just decide any dispute that interests them or that divides the country. There has to be some concrete a dispute between 2 parties, one of whom is injured by the law that's being challenged. So it's pretty interesting. President Trump put on the court, 3 justices, 2 of the 3 of them, Justice Kavanaugh, Justice Barrett, sign on to the Justice Breyer majority opinion. So does Chief Justice Roberts and Justice Thomas, also conservative justices, Republican appointees. So I actually think for, both for sort of future decisions of the Supreme Court and the kind of public's perception of the court, this is an important statement of the kind of transcendence of certain ideological or of certain legal principles, their ability to transcend, again, ideology and partisanship. So this is the Supreme Court basically saying, it doesn't matter if the party of the president who appointed us would like us to rule in a particular way in this case. There are legal principles that we have to abide by. And this, limited jurisdiction of the federal courts, the fact that they have to, sit back and only decide the cases that are properly before them is kind of one of those overriding principles. So I do think that it's an important statement that I think will mean future challenges to the Affordable Care Act, are going to have a hard time succeeding. And that just more broadly, hopefully the public sort of gets the sense from this opinion that, contentious political questions are not necessarily going to be resolved in courts, right? The political branches are the right place to sort of resolve some of those disputes, and courts are supposed to sort of, be in the background, just deciding the kinds of concrete disputes that come before them, but not resolving these important political debates like what the future of healthcare in this country should look like.
And Devin, I wonder what this does for the perception of the Supreme Court. As Kate mentioned, we've had a number of unanimous decisions so far. This one did not come down along what some people would expect the, quote, conservative or more liberal judges to decide on. And this comes at a time when the court seems to be becoming more political, not necessarily in their decisions, but in public perception and perception in Congress. We've seen Congress duke it out now in the Senate over whether or not to confirm certain appointees based on which president put them forward and where we are in an election cycle. And there was a lot of talk about this being now a conservative court, particularly with the addition of Justice Barrett after the death of Ruth Bader Ginsburg. So what does it say about the history of the court being apolitical, the way we've seen some of these recent decisions come down?
Well, a couple things, Diane. First of all, I think the fact that Justice Breyer authored this opinion is very significant, and the fact that it was so narrow and decided on standing also significant. This has been a project of Justice Breyer since he joined the bench, a quarter century ago, was to bring sides together, to find compromise, to be that broker. And here he appears to have done it, and he was the man leading the way, trying to thread the needle on this one. I think that's significant, and the fact that it's 7-2 also very significant, not along those traditional ideological lines. We've reported here and talked a lot, big picture, about how the court has been deciding cases so far this term. A majority of cases, nearly 70% of cases so far, there are still 15 left to go, have been unanimous. Diane, that is a striking figure. On average, over the past 10 years, about half the cases have been unanimous. And another major decision just came down a few minutes ago on a significant case involving religious freedom out of Philadelphia, a case involving foster care, Catholic social services, and LGBTQ rights. That case was decided unanimously in favor of the religious group in that case, which is very significant. It's a blow, will be seen as a blow to LGBT equality in this country, coming in the middle of Pride Month. A strike against the city of Philadelphia's attempt to roll back discrimination against LGBTQ people. But again, a unanimous decision by the Supreme Court, getting the liberals on board, saying such efforts by the city of Philadelphia are subjected to strict scrutiny under the law, and here striking that down. So a fascinating dimension of decisions so far coming from the court this year at a time, as you say, when it is in the middle of this political debate. Its decisions have been far from what many would expect based on the presidents who appoint them, Diane.
And Kate, I know you're pouring through that decision right now. What sticks out to you about this Fulton versus City of Philadelphia decision here on fostering?
So this is a fascinating opinion. As you said, Diane, it's about 100 pages long, and we've just gotten it, so we're all still digesting it. But basically, at issue here was a challenge by Catholic Social Services to a requirement. So the city of Philadelphia basically says that any agency that works with the city has to abide by general non-discrimination law, including a prohibition on discrimination on the basis of sexual orientation. And Catholic Social Services says we actually don't want to certify same-sex couples as foster parents under our contract with the city because we have a religious objection. objection to doing so. And Philadelphia has argued, well, everyone has to abide by the same non-discrimination principles, whatever objections you might have to those principles. And as Devin was just saying, the court has sided with Catholic Social Services and found that this Philadelphia requirement can't be applied to Catholic Social Services. So it is certainly right that religious liberty has prevailed over LGBTQ equality in this particular kind of head-to-head conflict. But it's a very narrow opinion that was able to basically keep the entire court on the side of Catholic Social Services, basically by saying that the city of Philadelphia gave exceptions to other kinds of organizations that had objections to various provisions of the city's regulations, but didn't give the same treatment to the religious objections of Catholic Social Services. So basically, the court seems to be saying that it's not that religious objections are more important than other kinds of objections, or that religious liberty is the most important constitutional principle as compared to, say, equality, just that in this case, the city of Philadelphia did not treat the religious organizations in the same way that it treated other organizations. So in the language of the opinion, that this requirement was not generally applicable. So again, I'm still sort of digesting the nuances. It is absolutely a win for religious liberty, but not the kind of full-throated announcement that religious liberty is, a principle in the Constitution that overrides all other principles, which I think people were a little worried that this opinion might say. And I think the fact that you have a unanimous court coming together to write a very narrow opinion in which the organization wins, but without, kind of clear implications for other disputes, I think is a testament to the court's desire to, try to stay unanimous or relatively so in these big high-profile cases. And also that Chief Justice Roberts, the author of the opinion, wrote a very savvy opinion, again, a very narrow one, but certainly a win for religious liberty.
And Devin, this debate over what constitutes religious liberty and what constitutes discrimination has been going on for quite some time now. What do you think this case does, not only for the specific issue they were dealing with before the court today, but that general conversation?
Yeah, this, you talk to advocates on both sides, religious conservatives and LGBT advocates, Diane, and both say, religious freedom in this country and LGBT rights don't need to be at odds. But this case is going to be interpreted, and as Kate just said, we're still trying to read through the finer points, 110 pages coming down. But ahead of this decision, we had been hearing from gay rights advocates that this was going to be an unmistakable message to gay people, gay potential foster parents, gay children in the foster care system. There's a disproportionate number of LGBT kids in that system. That certain groups can discriminate against those parents and send a very negative message and reinforcing stereotypes. So, at the surface level, the fact that the city of Philadelphia's policy enforcing a non-discrimination, rule on Catholic Social Services, can't go forward. Catholic Social Services will be able to continue screening parents for foster care in that city, and they can continue to deny same-sex couples in light of their beliefs. And so this is such a delicate issue, but we've learned this term that this court is showing a lot of deference to religious liberty, and perhaps today, as we continue to digest this decision, we'll see what kind of a standard they're setting going forward.
And so, Terry, when you look at the overall picture of what this does for the Supreme Court and the way the American public and Washington views the Supreme Court, what do you think, given today we not only have the court siding with what many would consider to be a conservative-leaning ruling and then another liberal-leaning ruling, but also the fact that these justices are not voting along the lines of what one might expect based on the presidents who appointed them?
It's fascinating, Diane. I think that inside the Supreme Court, they're working to find ways to resolve these highly politically charged cases that are brought not really for legal reasons, but for political purposes, as they found really in the Obamacare case, that those were plaintiffs who actually had suffered no injury. And here they looked at a portion of the law that rendered the case in a different light. They're trying to get out of politics, essentially. That what they are trying to do is back the political activists who are trying to use the court from the left and right to stir up the culture wars, to win total victory over the other side in these hot-button issues by getting a decree from the Supreme Court. And I think what you're seeing is liberals and conservatives, right, on the Supreme Court saying, you know, this should not be our role. Let's find a way to resolve this judicially, under law, with principles like standing and generally applicable laws that will enable us to articulate law and stay out of politics. And it is artfully done in both cases and is a message to so many activist lawyers and groups who are getting funding to bring these cases to the Supreme Court. They go hunting for plaintiffs. They kind of cook up plaintiffs sometimes. They want the Supreme Court to essentially issue political decrees. Obamacare is gone. You know, you can't discriminate against these religious groups in this way. And the court is looking at the facts of the case under the laws of the country and the Constitution, and they're saying, there's another way of resolving this dispute for us. Because we aren't in your political muck and mire. We're going to do it the legal way. And I wonder if it will have that effect, because it certainly is a strong message from them today that they aren't going to play that game.
And Devin, it's interesting that this all happens in the backdrop of increased pressure on Justice Breyer to retire. Democrats have been wanting to see him step down during Biden's early part of his administration to ensure that it is a Democratic president, President Biden, who gets to fill that seat. What do you think this does for that conversation?
Yeah, and a lot of pressure mounting just overnight, Diane, after Mitch McConnell, the Republican leader in the Senate, famously behind the blockade against Barack Obama's nominee to replace Justice Alito, Merrick Garland, a few years back, and of course pushing hard to get Amy Coney Barrett on the court just days before the election. McConnell yesterday said that if Republicans win control of the Senate next year, there's a good chance, potential chance, that they will block any nominee by President Biden in 2023 or 2024. That sent shockwaves through liberals overnight. New advertisements in major newspapers calling on Justice Breyer to step down, to leave the bench, to ensure that President Biden can replace him properly, easily to the court. Breyer's the oldest justice. He's 82 years old. Of course, they have a very divided 6-3 minority on the court right now. But I got to tell you, no one can tell a justice when to leave the bench, of course. And Stephen Breyer is loving his job. He is showing no signs of wanting to go anytime soon. In fact, Diane, he just gave a speech a few weeks ago pushing back on this idea that justices are beholden to the party of the president that appoints them. These aren't just talking points for Stephen Breyer. They are deeply felt, deeply believed. I've spent time with Breyer one-on-one. He's talked about it. You can see he really believes this deeply. So it's hard to see how this outside activity will nudge him towards the exit. Especially at a time when, as he said just last week, one of the things he's learned on the bench, Diane, is you don't let up. Perhaps that's another tea leaf that he plans to be here for at least another term.
All right. Devin Dwyer, Terry Moran, Kate Shaw, thank you all. And we will have a lot more on these cases at 3 p.m. Eastern on The Breakdown today. Thank you all for joining. I'm Diane Macedo. Have a great rest of the day.
Hi, everyone. George Stephanopoulos here. Thanks for checking out the ABC News YouTube channel. If you'd like to get more videos, show highlights, and watch live event coverage, click on the right over here to subscribe to our channel. And don't forget to download the ABC News app for breaking news alerts. Thanks for watching.